DEI. DEI is something I think that's it's been around for a while. We've heard it. What does it mean? What do you have? And I'm going to bring Courtney in here to talk a little bit about this. Courtney, you and I can kind of go back and forth. We've talked about this a lot. It's something that's the pendulum shifts on almost all topics and laws. We've talked a lot about that. This is one that seems to have a major pendulum shifting here, but there's also some bedrock law here. Can you tell me a little bit about what changes you've seen over the past year that have impacted the concept of DEI?
Yeah, so for the sake of time, I'll try to be very brief on this. But over the past year, we've seen the passage of several executive orders. We've kind of touched on it a little bit throughout this update. And those executive orders are aimed at eliminating preferences, mandates, policies, programs, and activities, whether or not they even identify DEI directly or not, that violate anti-discrimination laws from the workplace, for the federal government, contractors, federal grant recipients, right? We've been hearing a lot about that in the news, people who are being penalized, and then private sector employers. You pair that with some ongoing legal challenges that have been kind of carried over from the Biden administration, and DEI programs are under increased scrutiny, and it's really kind of leaving everybody in this place of uncertainty. And where do we go from here, right? So, I think at some point we probably got to break down the executive orders, and I know we're going to kind of touch on those in a little bit. But those are probably having the biggest sweeping impact right now on a lot of our clients.
Okay. So you mentioned those executive orders. Which executive orders should employers really be paying attention to?
I think for the sake of this conversation, there's three major ones to focus on. The first one, I'll just call it EO, Executive Order 14151. That's really geared towards the federal contractors, agencies, and grant recipients. Actually, not the grant recipients, sorry. It just has a good flow, right? And this executive order requires that all DEI and DEIA, which is DEI accessibility, mandates, policies, programs, preferences, all of that whole list for federal governments are terminated. It also instructs that all existing federal employment practices, union contracts, and training policies comply with this order, right? So it's really trying to take out the DEI piece to emphasize anti-discrimination. The second one, and this has a broader impact, is Executive Order 14173. Probably for our private employers joining us, this is the one they've heard the most about. This executive order revokes previous executive orders regarding illegal discrimination, and takes action or requires action to eliminate DEI and DEIA mandates, policies, preferences, activities, etc. It also ends the promotion of diversity within federal contract or with federal contractors and subcontractors. And I think the most notable piece, especially for the private employers joining us, is that it mandates the inclusion of a couple of terms in all contracts and grants moving forward. Those two terms, one is, and I'm really paraphrasing here, is that the counterparty or the recipient is agreeing not to operate any programs that are promoting DEI that violate any applicable federal or anti-discrimination laws. And then the second part of that is that they are agreeing that they will be in compliance with all respects, with all applicable federal anti-discrimination laws. And they understand that this is a material term to any kind of agreement and any future government payouts to them, right, based off of any of those grants or contracts. So that's probably the biggest one. Potential, I think, violations that private sector employers are likely to run into or run the risk of running into that would violate this executive order. Think about, if you're engaging in, activity that creates workforce balancing based on a protected characteristic, that would be an automatic violation. Or maybe you're, reserving exclusive spots in your employment chain for members of a protected class or characteristic. So those would be automatic dings under this executive order if you're a private employer or if you're somebody who accepts private funding from the federal government or
So
public funding
Courtney,
from the federal
are
government.
you saying that we've heard DEI now for a good 8 to 10 years as being
Mhm.
part and parcel of what a lot of employers are doing, but not only that, investors, if you're a private employer, community groups, people in outreach communities, banks sometimes. We've really been shown that this is important in the way that we do business and how human resources should try to do things. Are you saying that we need to really go back now based on the executive orders and some of the changes and look at how we hire and how we promote and some of the programs just to make sure we're consistent? Is that what we're looking at here?
Yeah, I think it just has to be consistent. This goes back to kind of the theme of some of our topics. Everyone is protected. So we've got to show consistency. We can't show favoritism. We have to make sure that our hiring practices, our promotional practices, our recruitment practices, what have you, look at the candidates equally, right? Not giving weight to any particular criteria outside of the scope of the job description. I'm trying to think of like even like a performance plan, right? You can't give a better bonus or something like that as part of a promotion or a performance plan based off of a protected characteristic. So there's a couple of things I think that we all need to be thinking about, but I don't think the intention is to do away with DEI per se. I think it's just about we've got to treat everybody on the same page, period.
So the impact, right? The impact of executive orders, anything else you can add on what we should be doing? What do we need to take away from these EOs, these EOs?
Well, I think, like I said, so EO 14151, that's really going to just impact your federal employees, your federal employers. That one is going to be more program related. I think the biggest takeaway there is violation of that particular EO is going to result in termination of all equity related grants or contracts. So if you are in one of those contracts or grant agreements, you've got to be really careful to see how this transition is going to impact those dollars coming through. It's also going to impact, DEI accessibility requirements for federal contractors and grantees. So that'll be really interesting. For EO 14173, for private sector employers, even though this does have some federal implications for private sector employers, I think you've got to be aware, you've got to make sure that you're not implementing any unlawfully discriminatory mandates or preferences, exclusions, or workforce balancing when you're making any kind of employment decisions. You've got to take the time probably for your protection, right, to review your policies, review your programs, review any activities that you've got in place to make sure they do not involve any kind of unlawful preferences or exclusions, based on those prohibited criteria that the EOs line up, or lay out.
I appreciate that. And I think what I'd like to do is talk a little bit, because segue from the executive orders
Mhm.
into general employment law. We talked a little bit above about how what the Supreme Court done, the federal government has tried to do is they've said, look, let's just make this simple. Stop discriminating. Okay, from a federal standpoint, it's really simple. The problem is there have been historic executive orders that have said, in order not to discriminate, you've got to do X, Y, and Z. And what some of these have done is said, yeah, we're going to take those out of here. You're not under it. In fact, if you do some of the things we told you to do before, you're going to be in trouble. Okay, I think that's what the biggest problem is. But that's only for people who are receiving generally some sort of grant or applying for federal funding. But there's also some real world how you apply law. But I will say the more things change, the more they stay the same. I
Yep.
want to go back to the 60s. And when I say the 60s, I'm talking about 1866. In 1866, you might remember we had a war. It was called the Civil War, and there was a law that was put into place. And what it said effectively was, look, you can't discriminate and not enforce a contract based on race. Okay. Now, there's something called Section 1981. We won't get into all this stuff, but Section 1981 cases were really big because what happened was African Americans in the South were having a hard time getting into contracts and people were just walking away and the courts were ignoring them. This law helped enforce those. Pretty busy. Then it kind of went away. All right, and it just kind of nobody really did it. And then it kind of had some other claims and it started coming. Now it's being used pretty consistently by groups saying, hey, You got to enforce a contract, including employment, equally, irrespective of race. And everybody says, well, yeah, we know that was for African Americans after the Civil War, after slavery. Oh no, that's not what it says the proponents of this new enforcement mechanism. And they've been very successful going after people, because there's two things that people have to understand, and I think it's lost. It's always the same. The EEOC has never said that affirmative action is the plan. What they've said is affirmative action is actually an exception to the normal don't discriminate rules. When you put an affirmative action plan together, if you look at their plans, they have been very specific. Either it's got to be a plan put in place because you're the type of employer that has been found to probably have engaged in pretty bad discrimination, so you need to put a plan in, or you go to the EEOC or Department of Labor and you get a discrimination plan, right? A plan to stop discrimination in your community. And both of those are approved, whether they're voluntary, involuntary. They have massive record keeping, and generally they're short term in nature. So that's always been the law for affirmative action. We're an affirmative action employer, which means we don't discriminate, is really what that means. And if you've got a program for affirmative action, it's because you've either been found to be discriminatory, you think you've been discriminatory, or you've been required under an executive order. So those are the exceptions, and we want to make sure we comply. And that's not going to change, because there still are some times when your contracts require, whether it be with the federal government or the state, that you do those things. It's very important. Now, DEI came from a different area. It was more of a social construct to push a movement to say, look, I understand the EEO laws are out there. Let's do more. Let's do better. Let's invest. Let's get better outcomes. And what I think the law is saying is that's great. We should have better opportunities to go out and get a bigger pool of applicants. Let's make sure we're not discriminating. Let's put programs and investments together, but you still can't violate Title VII. And as we've seen, you can't discriminate against any race. And these Section 1981 claims are going to be used by people to say, hey, my employment was discriminated against. Now, there's a higher standard for that. Just so you know, in the federal normal discrimination laws, there's a cap depending on how the size of your company if you get sued, like 300 grand. Section 1981 does not have a cap, so potentially. And so what we've seen is a number of lawsuits against programs that are set-asides just for one group, scholarship or internship opportunities only for one group. Those are being scrutinized. So if you've got an affirmative action plan that's proper and done right, it's still fine as long as it's approved and as long as it's done the right way or it's under a rule. But things haven't changed. In fact, what's happening is DEI can continue, Title VII can continue, Section 1981 continue, but you can't listen to a consultant who says, let me tell you what I think you should do. You better make sure it's consistent with the law. So that's the one thing I think people need to understand is things haven't changed. There was a big push to get things going. Many of those concepts were actually needed, but some might not have met the requirements. So make sure you're not doing it. People always say, hey, at the end of the year, we always take a look and make sure we got enough people to fit the community's look, right? We have this percentage of females. We have this percentage of African Americans, this percentage of Hispanics and Asians. We want to fit a look that looks just like that. Ooh, be careful with that. That could get you a 1981 suit. It could get you a Title VII suit if somebody doesn't get included if you're not part of an actual affirmative action plan. So, or you're mandated by an executive order or a contract from the state or something of that nature. So just be careful when you're implementing plans that have great ideas, awesome outcomes that you want, but they're not done the right way. And you can get yourself in trouble quickly because there are a number of lawsuits that we've seen this year and last year that have gone down that path. And there are well-funded groups who are putting money into that. And so that's just the way it is. And as Tony was talking about earlier, there are changes in those laws. So, Courtney, again, appreciate it. A lot of work, a lot of things, as always with all of our people, if you have any questions, please reach out.